All right, good afternoon, everybody. I am waiting for everybody to sort of sign in. We have participants seem to be signing on, so I'm going to go ahead and get started. This is a webinar, a brown bag lunch webinar put on by the Law Practice Management section of the State Bar of Georgia. I wanted to give a shout out to those folks who are helping to put this on. In the Law Practice Management section is a let me just plug them real fast. They do a lot of good for the bar, and they're also probably one of the bar's least known assets to attorneys, both young and old. And they do a lot more than one would think. And I would just want to give them a shout out and a plug and a note of thanks for putting this on, as well as many other programs. So today's topic is to catch a title thief. And what does that mean? The background of this, I want to go into a little bit of background if people are signing in, and then jump into our the slideshow. But basically, what I do, my name is Rick Alembic, and what I do is I litigate real estate related matters. I don't do closings. I don't do anything. I don't do much in the way of transactional work. So what I see is quite a bit of, I see the issues that occur when transactions go bad, when property owners have problems with either boundary line disputes or ownership issues or fraud and forgery. And so the topic, today's topic, deals with what I refer to as title theft. And before I get too deep into the subject, I want to just make sure everybody knows that at the end of this webinar today, there's going to be a raffle for a gift card. So everybody, I guess that gives everybody incentive to keep watching, no matter how bad this presentation might be. At least there's a gift card at the end of it. So think about it that way. This webinar is free. To get CLE, I can't tell you how to do that. You can probably check in with with Kim Henry at the Law Practice Management section, or she can chime in the chat box. But there is CLE available for 1 hour. It's going to cost a few bucks. If you don't want CLE, this is free, and you might even get a gift card out of it. So, and you might get some good information. I'm hoping to provide some information to not just real estate practitioners, but to kind of a broad swath of lawyers. If you have an elderly client or a client who may be incompetent, if you do fiduciary law, if you have clients, if you may be acting as a conservator for a client, I think this webinar is going to be fairly valuable, pretty valuable to you. And I've kind of backloaded the practical aspects of this issue in the outline and in the PowerPoint. The front loading is more of a background, kind of a background section, and also sort of just more of a practical discussion about what's happening in the area of fraud. So let me go ahead and just start. I think we got enough people in, and I'm going to share my screen. As mentioned here, let me start off with this PowerPoint slide. Focuses on protecting title to real property from the bad deeds of modern cyber criminals. Why is this an issue these days? And I'll start off with just kind of anecdotal discussion of my background. I've been practicing law for 30 years, and before that, I actually worked for my dad's law firm as a teenager. And back in the day, back in the 80s and really 90s, everything was done on paper. And so that made life fairly easy for people in terms of avoiding forged or fraudulent instruments, avoiding people being taken advantage of, because there's a paper trail. There's a paper trail for everything. If you wanted to record a deed in the courthouse, I used to be a courthouse runner. So I would, when I was a kid, I would go down to the court at Fulton County, DeKalb County courthouses and record real estate deeds. It was paper. You had people who signed as witnesses. You had notary publics. Everything was paper. There's a paper trail for everything. And those days are sort of, as we know, those days are sort of behind us. Nowadays we have electronic recording, where somebody can be in Kazakhstan and basically record a deed in Georgia, in Fulton County deed room if they want. And there's actually very little in the way of, I mean, there's some protections, but there's not as many as one would think. And I'm going to just allude to a couple of matters. Like even the legislature has reduced the protections that might be available. Like if there's a corporate transfer or transaction, a corporate cancellation of a security deed, for instance. Well, in 2011, the legislature made it much easier for someone to cancel a security deed. They don't even have to have a corporate seal. They don't have to have proof of that they're a corporate officer. It's basically just if you state you're a corporate officer on a security deed cancellation, it'll get accepted whether you actually are an officer of that corporation or not. That was code section 14-5-7. I was just recently consulted on a case in Washington, D.C. Involving a fraudulent deed that was basically sold a $500,000 piece of property just using a forgery. The lady who owned the property was an African-American female, but the settlement package that went to the next lawyer had a driver's license of this lady's driver's license suggests that it was not actually the owner of the property who sold it, because the person on the driver's license is definitely not African-American. It's almost that easy to perpetrate fraud. And the deregulation that we've seen with Secretary of State, it's very easy to get a corporation without any almost human contact. If you want a registered agent no longer has to sign wet sign an acknowledgement or acceptance that they are that they actually agree to be the registered agent for the corporation. All sorts of deregulation and cutting back of so-called red tape has resulted in a situation where it's just so much easier to forge deeds and cancel security deeds and whatnot. Combine that sort of development with developments, and I'm focusing on Atlanta, the Atlanta area, or really any area where you have gentrification. You have elderly residents who may have been in their homes for decades, generally have paid off their mortgages, and they own their homes free and clear. And so because you own a home free and clear, what that does is it makes it a lot easier for somebody to forge a deed and to transfer title to the home to, say, like a third party corporation or whatnot, because there's no bank involved. You don't have to pay off a mortgage, no loan. There's nobody supervising what's going on with this deed. So if there's no mortgage, or if the mortgage is fraudulently canceled, then that's one less layer of protection for people who may own their homes outright, but who may not have the wherewithal to identify what's happening around them, or to realize that their home may have been sold. And this is especially true when you're living in, for instance, someone owns a home and may be ill or move in a nursing home or something of that nature. They may not be in the home to notice that it's being cased, or it's being sort of targeted for possible fraud. There's a Channel 2 news story, and I think you can find that in the materials we have in the outline and in the I think the PowerPoint slide. But there's a link to a Channel News story about Linda Willis, who is a lady who had purchased who lived in her home for over 30 years. Her mortgage was paid off, and she ended up becoming she was ill. She ended up having to move out of her home for a while, and all of a sudden she's told that, hey, somebody's tearing down your house. She goes to her Ms. Willis goes to her property, and this is what she sees: her home literally being torn down. This was the result of a fraudster who had, long story short, had used the probate court to get letters of administration claiming that Mrs. Willis was dead. Mrs. Willis was not dead. In fact, I saw her on TV very much alive not long ago. And so using the probate court letters of administration, they were able to transfer the house to a third party or to their own corporation. That corporation transferred to a third party, and boom, the thief made off with hundreds of thousands of dollars. Now the problem here is, we just call the cops, right? They'll make it good. They'll go arrest the thief and give you your house back. Well, that's not what's happening. And I'm just speaking from experience, having done this for a while. The police and district attorney's offices are really bending over backwards to not prosecute these. I'm not saying they're not prosecuting them at all, but they're just not very helpful, especially like in Fulton County. There's almost 2 or 3 years of backed up criminal trials. And so if nobody's getting killed or shot or obvious traditional crime, it's just not being prosecuted. So what I've put together is sort of a top 10 list of kind of ways to avoid being a victim of title theft, or how to advise your clients on avoiding becoming a victim of title theft. And like I said, I've backloaded the some of the legal stuff towards the back of the outline, and so as a result, I'm going to kind of work into the legal stuff because that may take a little bit of time. I've left time for questions at the end, maybe 10 or 15 minutes. If there are no questions or everybody's still awake, then I also have a little bit of a bonus content for folks regarding avoiding becoming a victim of wire fraud theft when you're buying your home. So that'll be on the back end. The bonus content's on the back end once we get there. So let's start off with number one. As I mentioned, the most, and I've seen quite a few of these. I've had clients, I've been consulted. I've seen quite a few of these cases, and I think the most common denominator of these cases is a home is more likely to be targeted if it's clearly either abandoned or boarded up or just not obviously lived in. What that suggests to criminals is that either the owner is away or incompetent, or is just not necessarily going to be around to complain when someone else buys their house. So number one is make your home look like it's lived in, and that goes without. It's kind of self-evident, self-explanatory. Like avoiding burglary, you want to keep lights on in the house, or have them on timers. You want to have like one of these Ring cameras that or doorbells that just keep an eye on who is looking at your house. I mean, literally, these folks will. Sometimes they'll try to buy the house, or they'll knock on the door and see if anybody's home. They're casing the house, and so that is probably the first line of defense that I would recommend to anybody, especially someone with, again, who is especially a conservator of the property of somebody who's living in a house. The next, number two, and this is actually this is pretty good advice, if I say so myself. It's something that I actually didn't realize was an option until just recently, after I did some research. The notion of enhanced or a homeowner's title insurance. Exhibit A to the outline, if you have it. There basically are two general types of title insurance, real estate title insurance. The two general categories are owner's policy of title insurance for somebody who buys a home and may want to ensure that there are no hidden issues with the home, with its title or with its boundary lines or whatnot. The other general type of title insurance is a lender's, LTP, lender's title policy. And those are for lenders who lend money secured on real estate, who if there's an issue with the title or an issue with ownership, their collateral should be protected. So those two general categories of title insurance are where we start. What I'd like to focus on for purposes of this discussion is the distinction between, and it's Exhibit A of my outline, the distinction between and this is kind of nuts the way that the nomenclature works, but there's a standard owner's policy of title insurance, and then there's the enhanced homeowner's policy. So there's owners and there's homeowners. The homeowner's policy is what I would recommend everybody get. When you first buy your house, you can always get it later down the road if after seeing this seminar, seeing this webinar, and I don't get any commission on this, by the way. I'm just objectively saying you should get, if you own a home of any value, if it's worth investing in an enhanced owner's policy. And the difference between the regular owners and the homeowner's policy, is that the homeowner's policy will provide what's called post-policy coverage. And these would include, I'm just going to read from the Exhibit A. It'll protect against forgeries affecting title, even if they're after closing. Normally, title insurance is retrospective. It doesn't cover anything that happens after you close. The enhanced homeowner's policy covers things that happen after closing. So forgery, unauthorized leases, contracts, or options on the property, ownership claims that arise after the property is sold, easements or restrictions affecting use of the land, and encroachment of neighbors' buildings onto your land. So from my perspective, I see, these are things I see every day. I see these issues literally every day because that's what I do. Is that an accurate view of the world? Am I seeing the whole, is the whole world just a terrible place to live in where everybody's property is constantly being subject to theft or encroachment? Probably not. It's probably less than 1%, but from my perspective, that's all I see. So is my opinion or my position irrational or unreasonable? I don't know. But if you're following that 1%, then my opinion is definitely rational. It's not that much more to get the enhanced policy. Homeowners policy, it's maybe a 20% more premium. But again, based on my experience, based on the fact that we have electronic filing, the ability, fewer controls over what can be recorded, less interest by law enforcement in pursuing these types of cases, I think it's kind of a no-brainer. We're talking a few $100s for a typical home to get the enhanced coverage. Especially when one considers that a home for most people is going to be their biggest asset that they'll ever have. So it's just kind of a no-brainer to consider getting the enhanced policy. I just realized I'm probably sound pretty paranoid when to the folks watching this webinar, but even paranoid people have enemies, as they say. Anyway, let's talk about item number 3, protective title search. Especially if you are a fiduciary or a conservator, I think this almost should go without saying. You have a ward who has a owns a home, real estate holdings. It just makes sense to hire someone to do a update or do a title search on the property. You're talking less than $200, sometimes $175, $200, at least in Fulton County. Just do a title search, and especially you want to go back at least not just to the vesting deed, but you want to get the abstractor to go back a decent amount of time. For my purposes, I like to go pretty far back because I see what happens if you don't do a full title search. Sometimes it'll come back to haunt you. But a reasonable abstract should be good to see what is in the back chain, and what's more important is in the front chain after the property was purchased. One thing that's good to look for, especially if the owner, the record title owner, or the RTV, record title vest, I'll refer to that concept as RTV. If the RTV has a common name, John Smith, I guarantee you there's gonna be judgment liens and tax liens against John Smith. And so that's a good opportunity to see if there's some sort of lien or something that might be, that might not really belong to them, a judgment. If you do find that, just as an aside, it might be good to do an affidavit as to matters affecting title, just stating that I am not that John Smith who has that $2 million judgment against them, because that just kind of helps to clear the title. It makes subsequent title searches easier, but also it can identify potential fraudulent transactions. It can identify, especially if there's like a mortgage on the property, if it's been canceled and you don't know why, then that could be a precursor to fraudulent transfer. So just kind of goes without saying, a protective title search is just a good idea, especially again given that one's home may be the biggest source of one's wealth, and it just kind of goes with that, and it's a relatively inexpensive way of just making sure everything's good. Item number 4. So this is a good thing. The Clerks Fraud Registry. DeKalb County has a Clerks Fraud Registry, and Fulton does not, or at least last I checked, which was maybe a couple months ago. I think for Scythe, so I've not. Maybe a good project for like a summer intern, if somebody wants to do a search of all 159 or however many Georgia counties there are. But not all counties have what's called a Clerks Fraud Registry, and basically you sign up with your local Superior Court Clerk's office. You can do it online, usually just kind of Google it up, and you provide the name of the property, the RTV, the name of the property owner. You provide the tax ID number of the property. That's how they usually will identify your property and sort of track it. And in theory, you will get, if there's any transfer, any activity going on with your property, and that's usually going to be triggered by the filing of a PT 61, but there may be other ways of that's triggered. But you will get an email. In theory, you will get an email if anything's going on with your property. The obvious issues we have are, A, is that email going to get spammed? Is it going to be just, ignored? Is it going to be, are you going to change your email? Who knows? But it's better than nothing. It's worth looking into. I think the Superior Court Clerks organization, authority that is sort of responsible for supervising recording and things like that, I think they should probably be more proactive of encouraging the fraud registry. Again, it just kind of makes sense. That also raises the issue, and I've had conversations with a lot of people who work in real estate. Well, why not just get these title lock or home lock services that they advertise on late night television? Well, my initial response is anything that's advertised on late night television should probably not be something you want to buy. And that goes for these title lock programs. I mean, what they do is they will search for conveyances. They will check them, but that's it. They will just tell you if there's been a transfer, if something's happened. At least but you could also do that yourself simply by running a title search, basically for free, once a month, or having someone check it. They don't really offer much in the way of insurance or anything like that. So they're kind of, I wouldn't call them fraudulent. I would just call them not ideal. It should not be the only source of protection. So fraud registry. My next line of defense is consider retitling property. This probably goes more for if, say, there's a husband and wife, or someone who wants to, well, first of all, if somebody has a common name, John Smith, but if John has an unusual middle name, Xavier, or something, a name that's not typical, I would consider doing a deed that would convey, like a quitclaim deed from John Smith to John Q. Smith, or John Quincy Smith, or John Xavier, just something to make your name that much less common. And luckily, I have a sort of a uncommon last name. It doesn't mean I'm necessarily free. It's not going to protect me, but there are not that many alembics who are going to who can be confused with other alembics, and we all know each other, so that's unlikely to happen. But what can happen, and that goes to the issue of Mrs. Willis's property that I was discussing earlier. Mrs. Willis's property was stolen by a lady who had her same last name. Her last name was Willis, and so when this Mrs. Willis filed for fraudulent letters of administration with the probate court, I don't think it got a second look. Same last name as the RTV, therefore it made it that much easier for the probate court to issue letters of administration to someone with the same last name. So that's something that should be of concern. I would recommend, like, if it's a husband and wife who have not already titled their property as joint tenancy with right of survivorship, they may want to consider doing that, depending on what their estate planning or financial plans are. I think 9 times out of 10, a JTROS title between husband and wife is probably ideal, but not always. So that's something to consider with the assistance of an estate planner. But retitling property in that way can just make it that much more interesting, or that much more less likely to be the subject or the target of some sort of fraud. 6th point, consider a Heloc. Now, this is definitely, I've talked to quite a few transactional attorneys about this concept. I know some who swear by it and say, absolutely, if your property is paid off, you don't have a mortgage, try to take out just a Heloc with a local bank, not necessarily with a human, but ideally an institutional lender who, just a low limits Heloc. It's just one more line of defense against someone who may want to transfer title to your property, because if the Heloc is still on there, then they have to get paid off, or it has to be canceled by an institutional lender. The institutional lenders will monitor property to a certain extent. They check obituaries to see if somebody's died. They'll check title to make sure, some more often than others, but usually there's some degree of supervision of the property that represents collateral for their loan. So I think a Heloc is a good idea for that purpose. But if you're dealing with, again, maybe an elderly or incompetent owner, RTV, sometimes a Heloc is another avenue by which they can be ripped off. Family members will, have them sign a check on the Heloc, and nobody knows, and then all of a sudden the property gets foreclosed on because Heloc was never paid off. So take that advice with a grain of salt. It's fairly, again, it's going to be case specific, and I'm not saying generally do it. I'm saying generally just consider doing it and see if it's appropriate for this particular property. Another, again, this is definitely controversial, but I think it could be a good idea, is what I call a protective title affidavit. This basically would be something, it would basically be an affidavit one would record in the real estate records that basically states that, I live in this house, I don't intend to sell it. If anybody, if someone wants to buy this house, then they need to check with my lawyer or this family member or whatnot. Just something that'll go in the chain of title that that an abstractor will find if the house does start to get, is under contract or is in the process of being sold. I believe that such an affidavit is a really good idea, but I know other attorneys who think it's not a good idea, especially if the person who recorded the affidavit may later die or become incompetent. Well, how do you call that back? How do you recall that title affidavit? It could result in even having to go through litigation just to have that instrument canceled. I think it's kind of it's a potential tool. Tools can be misused for good. They can be used for good things. They can be used for bad. I think it's something to consider, especially with the assistance of a real estate attorney. So I am getting towards really what I think is the meat, or the pure legal aspect of what to do if kind of after the fact, after a theft occurs. If someone suspects title fraud, obvious time is of the essence, and this is one of those areas in which having a law degree maybe doesn't help you. Let me rephrase that. Having a law degree will obviously teaches you conceptual things about the law, but in terms of practicality, this is an area that's kind of ripe for problems with a lawyer who's not familiar with the actual tangible aspects of real estate conveyancing. We learned in law school that a forged deed does not convey title. Okay, it conveys nothing. Somebody who owns a property convey title, but if you don't own the property, no forged deed conveys nothing. So end of story, no problem, right? Well, not exactly the case, and this is why it's not the case is the subject of this next part. The important takeaway from here is that time is of the essence. You can't, if you suspect a problem, you can't sit on it. Even though law school says, oh, you can't convey, a forged deed doesn't convey title. Well, as a practical matter, it can. It could do so. Law enforcement is an obvious should be the first sort of line of defense. You should call local police department, advise that you think there's been a theft or forgery recorded. They'll write down your name, maybe they'll do a report, and then they'll put it in the hopper and probably tell you this is a civil case, we can't help you. If you go to the DA's office, they may escalate it just a little bit, maybe look at it more closely, but I'm just getting a little cynical in my old age. Do not assume that law enforcement will be helpful. One area where law enforcement could definitely be helpful is if you think that, for instance, if the property is sold and there's a loan made on the property, there's proceeds, and those proceeds may be wired overseas, who knows, there's proceeds out there, then the FBI has a really excellent potential excellent resource for possibly getting those funds back or mitigating whatever damages that could occur from the stripping equity of the property by making a fraudulent loan against it. And in the outline, I put a couple of URLs for FBI. There's the ic3.gov URL, which is good, which is more for wire fraud and things like that, but it certainly can't hurt to report there. Same thing with FBI.gov. Can't hurt to report. It can only help to report the theft to them in addition to local law enforcement. Okay, so this is where you help yourself, because again, I'm fairly cynical about law enforcement helping. The best tool or the best arrow in your quiver as a lawyer is the fraud affidavit. And what that is basically it's an affidavit as to matters affecting title, and it is controlled. This concept is controlled by OCGA 44-2-20, and I'm going to see if I can. Okay, I'm going to share. Let me stop the share and pull this up. Share screen. And boom. Okay. Oops, did I share the right? Are we seeing a PDF? Okay, good. All right, so this PDF here, I'm assuming everybody can see this. If you've fallen asleep up to now, or you want to fall asleep in 5 minutes, stay awake for this part. The fraud affidavit is important it has to be done right, because, and I'll kind of go into it just a little bit. Purpose of fraud affidavit is not just is to put in the chain of title your allegation that there is a fraudulent instrument in the chain of title. What that means is if this affidavit is done right, this will give what's called, I'm sure a lot of people are familiar with this, but I'm going to just kind of baby step through it. This will give what's known as constructive notice to the whole world. A proper recording of an affidavit relating to land will give, again, constructive notice to anybody in the forward chain of title. Anybody who wants to buy this property down the road, whether or not they check they run title on the property, they are presumed to have constructive notice of your allegations of fraud regarding this property, whether they see it or not. Now, to be careful about doing these, and I've provided a template that I think is pretty good, if I say so myself. It's not been tested in a court, or appellate court has not reviewed it, but I think it follows the statute pretty closely. And then let me preface my remarks on that by citing the case of Dollar versus Thompson. It's a 1956 case, and the site is 212 Georgia 831. Actually, it's 1957 case. 212 Georgia 831. And Dollar v. Thompson basically discusses the statute, the affidavit of title statute 44-2-20, and it makes clear that the use of the word shall in the statute makes it subject to a very strict construction standpoint. So be careful what you do when you prepare the affidavit. It's got to be filed in the county where the property is located. It's got to be cross-indexed to the fraudulent instrument, and it should be cross-indexed to the vesting deed, the actual owner, the deed that vested title in your RTV. So as you'll notice here, I don't know if for those of us who are not familiar with recording, this is the part of the instrument where you identify specifically what instruments should be cross-indexed when you record this. The good thing these days about recording is that cross-indexing is all you can eat. It used to be the clerk's offices would charge, like, I think it was $4 or something like that for each cross-index, and so we had to be kind of judicious in what we cross-index. But now it's a flat fee. It's a $25 recording fee and unlimited cross-indexes. So I think I filed a gatekeeper order not long ago in which we cross-index like 25 different instruments. And that cost basically nothing. It was still $25. So don't worry about cross-indexing too many things, but you definitely want to cross-index. Here is the fraudulent quitclaim deed, and here is the warranty deed that's the vesting deed. There's also certain magic language in the statute that requires you to create a caption that identifies the instruments in question. The current owner has to be identified, and the instrument chain of title has to be identified. So let me take that. And again, I want to hammer this point. And I envision several different scenarios where we're not doing this right could be problematic. This affidavit relating to land is admissible in evidence, and the statements made in this affidavit, for instance, here, paragraph 4 of the affidavit, the declarant states that I did not sign this deed as a forgery. Okay, so the declarant or the affiant is Jesse Duke. Let's say Jesse Duke is getting along in years. His property is stolen. His attorney is smart and records this affidavit. Jesse passes away a week later. Jesse's estate sues to have the fraudulent deed canceled or declared void, or fraud, whatnot. If this affidavit is not filed properly, if it's not prepared in strict compliance with the statute, it may not be admissible at trial later. And so if it's not admissible at trial and Jesse's dead, there may be nobody to testify the subsequent deed was a forgery. So this needs to be done right for at least that reason, for the reason that the admissibility of this affidavit is admissible as long as it's recorded properly. If it's not recorded properly, even if it's recorded, it may not be admissible. There may be no evidence of a forgery in a subsequent trial after Jesse passes away or becomes incompetent or whatnot. So that if you want to stop listening to me now, that's fine. This is the meat of what I want to sort of convey, is the importance of doing these affidavits of title properly. Okay, and let me go back to the PowerPoint. Share. Okay, so the fraud affidavit has to be done right. And that's the affidavit again. And buyers and vendors. So a little bit redundant from the first two parts of this section, but let me just reiterate. If litigation is pursued, and it probably will be, especially in situations where there's valuable property that's been purchased through a forged deed, I don't see title insurance companies or subsequent purchasers or banks. They're not going to just walk away from hundreds of thousands of dollars conceivably. They're going to try to find a way around it. That's just the way our society works. I'm just, again, call me cynical, but I anticipate there will be pushback. And how are these entities going to push back on a forged deed? You know, we bought this property, we lent money, hundreds of thousands of dollars collateralized on the property. We're not just going to eat that. All right, we're going to fight it. And how are they going to fight it? More likely than not, and this is, I'm at page 5 of my outline. It's 8C. The argument's going to probably be that the petitioner, to have this thing declared void, doesn't have clean hands. They didn't notify us in time. They could have recorded a fraud affidavit more quickly. They could have called. They could have advised just give an actual notice to the bank or to whoever bought the property, or maybe a material man. There could be a someone who's improved the properties and entitled to record a materialman's lien on the property. Even though there may be constructive notice in the deed records, if there's no actual notice, if the petitioner hasn't sort of made a strong effort to notify everybody as a practical matter of this fraud, I could see defenses being raised with respect to what's the, I think OCGA 51-6-4 requires parties and equity must be diligent or else be guilty of laches. There is no evidence. So even though you are in the right, you have legal right to this property, there's a forged deed, I can see a defendant stating, well, you weren't diligent enough about notifying us. You weren't diligent about perhaps noticing that, hey, somebody has forged a deed. There's maybe evidence that you were on notice of there being a problem before anybody would have been hurt by the forgery. So this is how the case is going to be defended, and that's why I would emphasize in my point number 9. Let me go forward. Well, that was C, but point number 9 is keep your hands clean. And again, we're talking about equity. One who silently stands by and permits another to purchase his property without disclosing his title is guilty of such a fraud as stops him from subsequently setting up such title against the purchaser. That's OCGA 51-6-4. So that's basically my recommendation. Do not assume that just by recording a fraud affidavit, calling the cops, that you're necessarily going to have your house returned to you with a red bow on the top of it. There will be resistance, and you need to guard against that as best you can. You want to be wearing the white hat, and that just kind of goes without saying for any type of litigation. You want to, even though the law is in your favor, whatever potential defense that can be raised will be raised, and you want to prepare for it. And number 10. So this is kind of I see this not, well, most forgeries, obviously a deed has to be notarized and requires someone with a notary seal to notarize it. And I would say most of the, I don't know what the actual statistics are, but certainly a good number of these fraudulent deeds are done with notary seals that have been stolen or lost. We have our practice in our office is, everybody in my office is a notary because, we do real estate and it's good to be a notary. But we don't leave our notary seals out. We actually lock them away in a locked filing cabinet with a padlock, and we don't tell people where it is. Probably shouldn't have just said that. Anyway, don't tell anybody that we lock away our notary seals in case somebody decides to case my office. But don't leave your notary seals out. Stolen notary seals are just one more way of facilitating these sorts of forgeries. It's just kind of sensible thing, but it's also a thing that people don't necessarily think about. And sort of in conclusion, let me see. So we're at the bonus content part of this talk, and I guess I'm trying to figure out, do we take questions, Kim, or should I keep going? Or is everybody still here? Is everybody still with me? Trivia question. Okay. Do we have any questions? I don't see any questions. 2 new messages. Okay, so either I did a great job with this discussion or everybody's asleep, so there's no questions. So what I'm going to do is go forward with the bonus content. So what I've just talked about for the last 45 minutes was what happens after you buy your house and after the fact. I'm going to do a little bit of retro. I'm going to go sort of just retroactive, and this shouldn't be more than a few. This shouldn't take long, but it's worth discussing. And I've seen it. It's something that I see very often, actually quite often now. Although I think it's hard to say if it's getting better or worse. I don't know what the statistics are, but I get regular calls about folks who how do I do this? Okay. About folks who have been ripped off because they're going to go sell their house, or they're going to buy a house, and the law firm that's handling the closing, the good firms are being a lot more proactive about advising folks not to get wiring instructions in any way that's sort of unconventional. The wiring instructions should already be sent to whoever's buying the house, or whoever has to pay money to the closing firm for purposes of closing. They'll usually be very specific about what the wiring instructions are. And what happens, the way that criminals will sidestep that is they will actually, I mean, and it's crazy how sophisticated this gets. They'll actually spoof the law firm. I mean, they'll have a website, they'll create a website, they'll create email addresses that are not really the law firms, that looks like the law firms. They'll implant rules in the law firm's email system so that if a email comes in from somebody, it's automatically forwarded to someone else. It's ingenious what they can do. So the simple way to address this is very simple. Call before you wire. Call the law firm. Make sure you're calling the right number, because on these fake websites they could have they'll have fake phone numbers. So find the law firm that's doing the closing agent. Maybe double check their contact information on the State Bar website. Just double check the phone number, call the firm before you wire, and just make sure the wiring instructions are good. And like I suggested, if the instructions change, that should be, if somebody says, oh, don't wire to this bank, wire to that bank, that should be a red flag right there. And you should definitely be making a call to that firm to just double confirm the correct wiring instructions. Now, and again, I must really sound paranoid. I'm convinced, maybe I am paranoid, but I see this happen, and so that's why I'm giving this talk. Social engineering is probably the prime means by which folks are targeted for this sort of wire fraud. So my advice is generally to, if you're selling or buying a house, there's always that temptation to announce on social media, buying a house or selling a house, whatever. I would say half of my Facebook friends are probably fake. Well, maybe not half. I'm sure I have a lot of fake Facebook friends, or I'm in groups where a lot of the friends are not real. And the reason why there are fake Facebook friends is because this is the way that criminals they socially engineer situations. They find out what's happening in people's lives. Are you gonna be on vacation next week? Well, that's great. So your fake friend will relay that to a burglar who will he'll burglarize your house while you're on vacation. Same thing happens with closings. I would go out of your way not to publicize the fact that you're buying a house, because that's just a trail. It gives a criminal potential trail to identify the closing firm, to identify the all sorts of information that could be used to set up these frauds. I would even, like, if you don't need a for sale sign in your house, like if it's under contract, why do you need a for sale sign unless you need maybe a backup contract? Take the for sale sign down. The for sale sign is for your realtor. It's advertising for your realtor, basically, is what it is. So I would take that down, especially if it's an under contract. Nobody needs to know that. Again, that's just one more sort of avenue by which criminals can engineer a wire fraud. What else? And so, and this is not in the outline, I probably should have put it in there, but we've had a lot of success in getting money back that has been stolen. I had clients who lost literally, like, one set of clients, I think it was like $120,000, $150,000 or thereabouts, because the closing firm got spoofed. their email got, the wiring instructions were from a fake email, and they wired their funds to a bank that was like up in New York and some place that was not the right bank. And using like the FBI, and again, these URLs are in the outline, but the FBI can definitely, in working with your bank, the money can be retrieved. Sometimes it can't, but a lot of times it can. And so again, time is of the essence with respect to wiring instructions that are fraudulent. Okay, let me see if there are any messages. Oh, I have a question. Hold on. Okay. All right, there's one that's fairly technical. I'm happy to take that. That's a good question. There's one that's, okay, I got a couple of questions. So why would a protective title affidavit be controversial? In a word, laziness. Maybe laziness isn't the word, but it's I think it's a good idea because I can see what can happen, but it makes abstracting that much more difficult if someone has expressed an intention not to sell property or given some instructions that can't be resolved. That could create problems with the title insurance company. They may not want to insure over that particular issue. They may have it may cause a problem with getting title insurance. To me, it's a tool. You have to balance the issue, whether if you talk to a title, an underwriter for title insurance company, they will probably roll their eyes at this, but hey, it's situational. And I would definitely talk about that issue with closing attorney or wherever you want to get title insurance from. But that's the reason it would be controversial. But if things weren't controversial, then they wouldn't be interesting, would they? Another question, and this is a good question. If you do find fraud, let me read this. If you do find fraud and have to file a quiet title action, do you always file against the world? There are two ways of doing it, but it seems like to be able to get the title insurance in the future, the action against the world is required. And that's a great question. So I think the answer is yes. If you're gonna, most title insurers, now if you don't care about having title insurance and you just want to try to get a fraudulent deed off your record, a simple conventional quiet title action is more surgical. Declaratory judgment action may be an option. But the answer, yeah, most title insurance companies probably are not going to be happy with the conventional quiet title, which economically is generally going to be a lot more. It's just going to be more simple, more surgical. A full-blown quiet title action, and I give a regular quiet title action CLE, and it's about an hour and a half or so, and I think it covers most issues that can come up. But bottom line with the full-blown, I call it a 1966 Act quiet title action against all the world, is it's expensive. It requires you have to file a survey. You have to, even if boundary lines aren't an issue, you have to serve adjoiners. You have to publish. You have to have a special master appointed. The special master makes recommendations to the court. The court can accept or reject the special master's recommendations. So there's many opportunities for that sort of proceeding to be sort of, I'm not sure what the word is, but not necessarily efficient. It's not the most efficient thing. I happen to enjoy them. I've probably handled or supervised more full-blown quiet title actions than anybody in Georgia. I like to think, maybe not. But it's definitely the gold standard. And my guess is that if again, it's going to be case specific, but I think if you want to preserve options for title insurability, yeah, the quiet title action will do it. The full-blown 1966 Act quiet title action, but you're also dealing with, to do a conventional quiet title surgically, $4,000, $5,000, $6,000. Full-blown QT, it's not going to be done for less than $10,000. And then if it's contested, just keep on racking up. But yeah, the actual remedy, I think there's a footnote in the outline, is a little bit beyond the scope of this sort of lunchbox brown bag lunch discussion. But it's a great question, and maybe for another day, or if you want to, attend one of my quiet title action CLEs, which I give a couple times a year, that'd be a good time to discuss that more in depth. And are there any more questions? We have a few more minutes. Kim, do you want to take over? What are we doing at this point? Are we going to raffle? Okay, so Kim, all right. So y'all check out the chat box for a second. So do we have a winner? Oh, looks like we got a winner, no? So congratulations to Aisha Thomas. You are the winner. Or is it Joel Beck? Joel Beck is the winner. Sorry, Aisha. All right, so the question was apparently, the guide to starting your Georgia law practice is the program's most popular resource. What is its other name? And the correct answer was the Office Startup Kit. Oh, we have one more question. Do we have time? Do I have time to answer this next question? I'm going to go ahead and try to answer it until I get cut off, I guess. If a person is refinancing, do they need a new title policy? The answer is technically no, but it doesn't mean that they can't maybe try to, because I mean, as long as you have your owner's policy or your homeowner's policy, it's good forever. But when you refinance, that may be an opportunity to maybe upgrade your title policy to a homeowner policy, the enhanced policy. And so that's something I would bring up with the closing firm that's handling it. Hopefully that closing firm also maybe wrote the original title policy, but I can't really advise as to how to handle that. But it's a very good question. Definitely find out the closing firm and just let them know that you would like to get an enhanced title policy. Anyway, I think we're getting close to the end. I want to thank everybody who's still awake for staying awake, and appreciate your taking your lunchtime to listen to me rant and rave. It's almost therapeutic for me to give these discussions. So thank you for attending, and enjoy the rest of your day.